Hey, everybody. Hopefully, I am live. Welcome to the Law of Self-Defense, an impromptu live show for March 31st, 2020. Thank you all for coming. We're going to talk today about the Michael Barisone case once again. I hadn't expected to cover it much, but then I realized yesterday that they were doing the cross-examination of Lauren Kanarek. Lauren Kanarek is the woman the defense is trying to portray as someone who intentionally sought to drive Michael Barisone crazy to the point where he shot her, really, literally bought her insane. Yes, I don't have the lighting quite right in my office. Sorry, I'll fix that in just a moment. So Michael Barisone is I called it a horse farm, and someone chastised me and said they don't grow horses out of the soil, so I'm using the wrong phrase. But sorry, folks, I'm a city boy. I'll call it a horse farm for the time being. And he ran a horse farm. This woman, he was a former Olympian dressage rider, whatever that is, and he had now trained people and horses for that Olympic sport. Lauren Kanarek was invited to stay at his farm to learn this Olympic sport. She brought with her her boyfriend slash fiance. It's a little ambiguous what he was at what particular point in time. And the relationship between Michael Barisone, the owner of the property, and Lauren Kanarek and her boyfriend, who were residing on the property, became extremely toxic. And apparently, there's evidence to suggest that Lauren Kanarek, her boyfriend, and her father all conspired to, in effect, drive Michael Barisone crazy. He appears that perhaps he was not all that stable mentally to begin with. He had a history of abuse in his past from childhood onward. So they looks like, at least the defense is arguing, that they literally drove him mad until he got to the point where he shot Lauren Kanarek twice in the chest and shot at her boyfriend. She would survive the shots to the chest, and the boyfriend was not struck at all. So this is not a murder trial. This is a attempted murder trial. Of course, this happened in New Jersey, so there's also a gun charge for him possessing the gun. There you go. That's what you get in New Jersey. And it's also being characterized somewhat as a self-defense case. Now, we covered the opening statement of the defense and of the state a couple of days ago. And the defense opening was about 40 minutes long, maybe a bit longer than that. And they spent, I don't know, I'd say 95% of that talking about this conspiracy to drive the defendant crazy, and maybe 5% on aspects of self-defense. So it doesn't really feel like a self-defense case to me. But the cross-examination of Lauren Kanarek, now the only people who were witnesses to the ultimate event, the shooting, were, of course, Michael Barisone himself, who fired the shots, Lauren Kanarek, who was struck, and her boyfriend, who was also on scene. So evidence of self-defense or not is going ultimately to have to come from one of those three people. Michael Barisone's probably unlikely to take the witness stand. We'll see, I suppose. But it will be interesting, I think, to see how the defense conducts their cross-examination of Lauren Kanarek. Are they really conducting it to emphasize self-defense? Isn't it true that you charged at my client? Something along those lines. Or is it going to be, again, 95, 98% focused on, aren't you a horrible, nasty witch of a woman for trying to drive this poor man crazy? We'll see how it goes. Yesterday was start of cross-examination. So the first couple things we'll see are recorded from yesterday, although, of course, my commentary here is live at the moment. If you're watching this on March 31st, starting at about 12:15 p.m. Eastern time. And it's continuing today live in the courtroom. So we're 2 hours plus into this. I would suggest we're probably close to 3 or 4 hours into the cross-examination of Lauren Kanarek total. We'll probably just cover a couple of hours today, maybe that much. We'll see how it goes. If it gets boring, I certainly won't keep you here. And this is more of a because I'm also naive to this cross-examination. I have not watched it, so I'm going to be watching it with fresh eyes, just like you. If it gets slow, or there's breaks, or there's other cases you'd like to ask about, feel free to do that in the comments. Of course, they would need to be super chat comments in order for them to be brought to my attention to answer. For those of you who are Law of Self-Defense members, you ought to be seeing this in the Law of Self-Defense dashboard. your membership dashboard. I know, Oscar, I see you here yesterday or the day before. You made a comment that you weren't seeing it in that video in the member dashboard. When I looked, it was there. So maybe you need to refresh your page or log out and log back in, or restart your computer, or contact support@lawofselfdefense.com, because there may just be an issue on your end in particular. I know it was there because I was responding, and it's there right now. I'm watching it. So there were people responding in the chat, in the comments. I was writing in there. So it's working, Oscar. It may also be working on Rumble. I tried to set it up to work on Rumble. Sometimes that works, sometimes it doesn't. It's certainly working on YouTube because all of you are here. Again, I see people asking me to do things in the comments, but I won't have time to scroll through all of those when breaks occur. So please put them in some kind of super chat manner, and then they're aggregated by YouTube to facilitate my ability to answer those. So I'm going to play a quick little intro video here. It only lasts about 10 seconds. If I'm not at my desk when it ends, that's because I ran around the backside of my desk to adjust the lighting in my office. So I have not gone anywhere. I'm still here. And here we go with that video. Okay, I guess I am back. Welcome, everybody. All right. So hopefully the lighting's a little better now. Sorry about that. A lot of buttons to press before we start a professional broadcast like the Law of Self-Defense show. Okay, so I'm going to jump into this first live streaming of yesterday's start of cross-examination of Lauren Kanarek. And we'll just, in the Mercado law fashion, we'll just comment as interesting things happen. Now, keep in mind, this is cross-examination by the defense. They're allowed to ask leading questions. They're allowed to be aggressive. They're really going to be allowed pretty much to treat her as a, as you all generally are in cross-examination, as a hostile witness. She is hostile. She's the woman who was shot. Now, of course, there's a couple of defenses in play here. One is the insanity defense, and in their opening statement, the defense explicitly referenced the insanity defense. It's a very high bar. Basically, you have to not know that you're shooting a human being. You have to think the person you're shooting is a space alien or a robot or some kind of monster. If you know it's a human being, then you know you're doing something wrong, unless, of course, you can justify the shooting on the grounds of self-defense, for example, which was also referenced by the defense here. But, of course, self-defense requires those 5 elements of self-defense. 5 elements of self-defense. In fact, just to remind all of you, you can get this PDF download absolutely free. It's here someplace. Let's see. There we go. The 5 elements of self-defense infographic, not printed, of course. It's just a PDF download, but it's completely free at lawofselfdefense.com/elements. These are the 5 building blocks of any claim of self-defense. If you don't understand these 5 elements, you can't possibly understand self-defense law. Now, this is a maximum of 5. Sometimes not all 5 are required. In New Jersey, all 5 will be required. New Jersey is a duty to retreat state. So generally speaking, all 5 of these elements will be required. The elements are innocence, imminence, proportionality, avoidance, and reasonableness. So for Barisone to have a viable claim of self-defense, all 5 of those elements have to be present. He has to have been the innocent, non-aggressor, victim of an imminent threat, of a reasonably perceived imminent threat of death or serious bodily injury from Lauren Kanarek at the moment he fired 2 shots into her chest, and from the boyfriend at the moment he fired at the boyfriend. Not sure the facts are going to be present to support that claim of self-defense. And if it's not insanity defense and it's not self-defense, then we're kind of in a realm in the middle space where an acquittal seems unlikely. I mean, maybe you could make the victims of Barisone's use of force or threat of force sufficiently unsympathetic that they make him look sympathetic. Maybe that might lead the jury to attempt to compromise on some lesser included offense other than attempted murder. New Jersey also recognizes the legal doctrine of imperfect self-defense. Imperfect self-defense cannot lead to an acquittal because it's imperfect. Generally, it would apply on the facts of this case where Barisone had a genuine, subjective, good faith belief that he needed to use deadly defensive force, but that belief was objectively unreasonable. Maybe because these people drove him crazy. He had that subjective, genuine belief, but it was objectively unreasonable. In that case, you can't get an acquittal because if you don't have objective reasonableness, you can't have self-defense, the perfect defense of self-defense. But you may qualify under New Jersey law for imperfect self-defense. And the effect of that would be more typically if you had killed someone, instead of being a murder conviction, they would mitigate it to a manslaughter conviction. In this case, New Jersey, at least one appellate court decision from the New Jersey state courts that I've seen would also apply that paradigm, mitigating attempted murder to attempted manslaughter. They recognize attempted manslaughter. Normally, an attempt crime, the punishment's the same as for the crime. You don't get a break for failing in your attempt. So in theory, the sentencing difference, mitigation, would be the same. Manslaughter conviction sucks, folks. It's 10 or 20 years in prison, depending. But you may be eligible for parole in maybe a third of that time. So you may serve, 3-4 years or 7-8 years and then be released, still have some kind of life afterwards. Murder or attempted murder would normally be life in prison without possibility of early release. So much worse than a manslaughter conviction. For those of you who are law self-defense members who can't see it on your dashboard, could you let me know if you're a platinum member or a standard member? Maybe that's one of the issues. I'm looking at the video appearing on my dashboard, but of course the system recognizes me as a platinum member. So maybe I can get someone to try to fix that in real time as we move forward. In the meantime, it's on both YouTube and hopefully on Rumble, so you might check it out there. Let's see. Yeah, okay, so I see some super chats coming in asking about other trials. I'll address those as we get to breaks. Okay, folks, if that makes sense. But we have the video of this, and we're going to support this. One thing I will say about Lauren Kanarek is, well, I'll wait until the video starts. But that's where we are with the possible legal defenses and the criminal charges. So with that said, let me close out the 5 elements of self-defense and bring up, hopefully I can bring up the first portion of the video here. Which one is this? Let's see. Looks better on my screen, perhaps. Come on. Which one is this? Boy, it's really hard to tell. Yep, this looks like the first portion. All right, so I'm going to go ahead and hit play here. And got a full screen like that. And the judge should lift his head in just a moment and invite Lauren Kanarek to the witness stand, get her sworn, and we'll start to hear her testimony.
You can have a seat, Ms. Kanarek. You remain under oath. Cross-examination, Mr. Blinkus.
Good afternoon, Ms. Kanarek.
Good afternoon.
Are you currently suing Michael Barisone?
Yes,
You're claiming millions of dollars in damages, correct?
I don't know the amount of money that we're claiming, but certainly for damages.
You basically want to take everything of value away from Michael Barisone in that lawsuit, correct?
I just want him to cover medical expenses and answer for the crime he committed in a civil court of law.
And also get money, correct?
So this is a weird way to start cross. He's starting with
I guess that's
the fact that she's suing him, Michael Barisone,
All
civilly.
of that
I mean, maybe you want to get to that eventually,
is based on
because
the
of course
fact
it
that
goes
he
to
shot you on
bias.
correct?
I mean, it certainly goes to bias, but wouldn't she be biased enough by having been shot by the guy twice? Let me see if I can do anything about the volume here.
That you, your boyfriend, and your father were planning on suing Michael Barisone prior to that.
Not that I recall, but I don't remember what we'd be suing. him
Is that better for the
for
volume,
prior
folks?
to that, Other
Do you
than,
recall talking to your dad about suing him for approximately $200,000?
I do not,
It sounds better on my headphones.
I know, I don't recall that actually.
Is it your sworn testimony that as you sit here today, you have no recollection prior to the shooting of talking to either your boyfriend or your father about suing Michael Barisone?
It is my sworn testimony that I, at this time, do not recall
Hey, Freddie Merck. Freddie Merck is a,
money.
I don't know why you're not appearing as an admin here.
Now,
You should be an admin. Maybe
you
you need
have
to
a
be signed
plan
in under your actual
to
name for
destroy
that.
Michael Barisone.
At some point, yes.
And isn't it a fact that you made a specific threat saying that you intended to destroy everything Mary Haskins loved and held dear?
At some point, yes.
So
You
this,
made that statement for both Mr. Barisone and Ms.
oh,
Haskins
thanks,
to
Manad
hear,
Proxy.
correct?
Good. I'm glad he's showing his
And
Ahmad.
would you agree with me that you set out on a mission to try to do that?
So
correct?
this video we're watching of the courtroom, this
Yes,
happened
you're very
yesterday.
correct.
I'm live, but this is yesterday's cross-examination. I wasn't aware of it until last night, so chose to cover it this morning.
There's been testimony here that no one ever really asked you to leave. Were you asked?
Wait, Mr. Blinkus, you can't refer to other testimony to this
I'll rephrase the
witness.
question.
Strike that. Just ask a question of this witness, please.
Isn't it a fact that you were asked to leave in July?
No, I was not asked to leave in July.
That's a poorly phrased question for the defense, because she could then just argue later if she's compromised on that answer, saying, "Oh, I thought it was June." Just ask. Isn't it true you were asked to leave at some prior point?
How about April 27th?
And then, if you want, you can narrow in on the
2019,
specific month if it's
where you
important for
basically
some reason.
told,
And yes, I was going to mention Lauren Kanarek. It's
Time
rather
to leave.
amazing she can
Can we clarify
hold
who
her
was
eyes open or even
reportedly
hold her
telling
head
about-
up. That looks like about 15 pounds of eyelashes.
did you have a
but-
conversation with Michael Barisone?
I had a conversation with Michael Barisone, Mary Haskins, my father, and my boyfriend in a meeting that I called, to which Mary Haskins began that meeting with, "Y'all need to leave." So yes, that would be correct, I guess, in the way that you asked it.
This is the lady who was shot twice in the
When you
chest.
were told you all need to leave, did you start taking steps to pack up and find another place to stay?
No,
Now, at that point in time, would you agree with me that things have turned sour between you, your boyfriend, and everyone at Dressage Stables?
I would not agree at that point in time.
Again, a
No.
poorly phrased question.
Since Michael.
Your relationship
in
became
that
bad with this
meeting,
person, that person, and
told his
everyone.
girlfriend
Well, she's going to
many
deny
times
everyone.
To, I'm just quoting here, so please don't mind the cursing, to please shut the fuck up and not speak again. This is a business arrangement and she should not be making any kind of assertions such as you need to leave or whatever. So that was the end of that conversation.
Now,
The guy with the yellow tie is the defendant. If he looks
When-
crazy, it's because,
did
well,
the
he looks
problems
crazy. He did
start
not
to
look like
occur?
that in the past. When this event happened,
I would say
he
they
looked normal.
started to occur
Now his demeanor is certainly that of
somewhere
someone
in the
who's mentally
area of
broken.
maybe July-ish, I want to say.
Now,
maybe
there's
a
three
little
people
earlier.
involved on the
but
other side of Michael
July would be
Barisone's
probably more
conflict. One is
accurate.
this woman,
When
Lauren
it's
Kanarek.
in
July.
She was the dressage student, I guess, so to speak. Although she's
approximately
40
a month
something.
before the
She's
shooting, correct?
not of an age you would normally think of as an Olympian
Now,
athlete. At least I
Have
wouldn't.
you ever lied
Then
to
there's her
either the
boyfriend slash
Washington
fiance
County
that
Police
lived with her,
Department
in the
or the
same
Morris
home on
County
the horse farm that
prosecutor's
Michael
office
Barisone
about
lived.
this
So they,
case?
they were all in the same
Not that I
castle, so to
recall.
speak. And separately is
Have
her
all your
father,
statements
who has some, to my mind,
that you
ambiguous
made to
role
them
in
been
arranging
truthful?
all of
Yes.
this, staying on the property, taking
Have you
instructions,
hidden
suing
anything
him.
from them?
No.
And certainly the defense has presented them as a trio. Lauren
You
Kanarek, the
gave a
boyfriend, and the
statement
father
December
as
5th,
collectively seeking to
2019
drive
the
Michael
prosecutor's
Barisone
office. Do
crazy.
you recall that?
No, I'm sorry. Can you actually repeat the question? I missed the date.
Sure. December 5th, 2019, you gave a statement to the Morris County Prosecutor's Office with regards to this case, correct?
December 5th, 2019. Okay, probably yes. I don't remember the dates, but
Almost 4 months after the shooting, correct?
okay, yes, then probably yes.
Now, that is the first time you gave them an official statement, correct?
I don't recall. I believe I spoke to them before that, but I don't remember.
That correct, Chris?
Yes.
Recently, in preparing for trial,
Well, so far I'm
You were playing your
unimpressed
video
by
of
this
this
defense attorney. The
transcript,
manner in which
and I'm
he asked
showing
the
you
questions on
200
cross
Gs.
allows her to be
Okay.
vague and ambiguous in her responses.
Was that a yes? You will play the video?
Oh, that was a question? I'm so sorry.
I think it was. Was that a question?
Yes, Judge.
Yes,
Will
will
you
you
play
play
the
the
video?
video in preparation for trial?
The video
of your statement.
of my
Tape
statement.
statement.
Yes, yes, it was.
Okay, and you went over that with the prosecutor, correct?
Correct.
Was there anything in that video statement that was inaccurate?
I can't remember it exactly. I feel like when I was telling them the amounts of shots fired, I feel like I said definitely 3 times, maybe the times a bullet shot. I couldn't really remember.
Didn't you say there were 5 shots?
I don't know what amounts of times I said. I know I said 3 shots were fired. I may have said 6 shots. I don't remember.
Okay, so a few months after the incident, when you talked to the prosecutor in official capacity, your
This-
recollection is
So this is all
3,
pointless
4,
to me.
5 shots.
She gave a lengthy statement. It's very common for people in the aftermath of the use of force
Yes.
event to be unclear on the
I guess so,
details.
yeah.
The way the brain
I just been shot a few months before,
captures and
so-
stores and recalls
I've seen
information
the
under
statement
stress is
before.
completely different than our normal experience. And how does this help the defense if she misremembered how much? It's undisputed
Yes.
that he fired
Now,
2 shots. Michael Barisone, the defendant,
before
fired
you
2 shots
gave that
into her
statement,
chest. So is
you
there a
had,
legal excuse like insanity or a legal
talked to your
justification
boyfriend
like
numerous
self-defense
times about
that
the incident,
relieves him of legal
Yes.
liability for firing those
And
2
you
shots
talked
into
to
her
your
chest?
father about the
What is her
incident, correct?
recollection if it was 5 shots total fired or 3 shots or 10 shots?
Was Robert
what difference
Goodman
does that
in the
make?
room when you gave that statement to the prosecutor?
I don't think so.
Now, would you agree with me that in your original statement, you said that you had a problem remembering the incident? Did you say that?
They took
In my original, sorry,
she
in
had
my
2
original
gunshot wounds to the
statement-
To
chest.
the prosecutor's office, the ones that.
That's
right
undisputed,
in front
obviously.
of you.
I'm sorry, I'm just confused.
If she
I'm
had
not
trouble
sure
remembering
that
the details, that does
this
nothing to
December
explain away
5th
the 2
was
gunshot
the
wounds to her
first
chest.
time I gave a statement. And there was some,
Judge, can I just clarify for the record, the interview occurred on September 5th, 2019. I think
not
the
December.
transcript says December 5th, 2019. So there's a typographical error there, but certainly the recording itself indicates it was September 5th.
What's the date, counsel?
September 5th, 2019.
No, they didn't want to cut his hair because they want him.
I see
A comment here. They should have
Right,
cut defendant's hair
it
like
may
they
be.
did for Edgecombe. Edgecombe, his actual haircut at the time of his shooting of the lawyer in that case
September 5th,
might be perceived as some as a haircut consistent with a criminal.
Yes.
So they cut his hair to make him look more presentable. Here, you would want Edgecombe to look crazy if you're going for an insanity defense or going for some kind of sympathy, lesser included offense in this case.
Do you recall telling the prosecutor at that time?
Yeah, the Edgecombe sentencing
that
is
it's a
coming
bit
up.
shady
I
in my
think I have that on my
mind, or
calendar.
words to that effect?
A week from tomorrow. So April
Honestly,
8th.
I was on a ton of pain
I
medication.
may cover that. It's not really
I just
important
come
in
out
any
of the
substantive
ICU.
way, but it'll
I
be
honestly don't know what I may or may
great
not
watching
said,
Judge
even if I watched the
Borkowski
video. I honestly don't
sentence
remember what I said
Edgecombe.
in
That'll
that
be great
video.
fun. So maybe I'll join Nick for that. I'm sure he'll
Page
cover it.
4,
Sure.
line 12, and ask you if that refreshes your recollection as to whether or not you indicated a month or so after the incident that you were a bit shady as far as your recollection of the event.
I'm so sorry. I can't find where you're talking. Line 12
Page
says
4, lines,
that's okay from Detective Rogers. Making sure I'm on
What page is it,
4
Mr.
here.
Blankus?
4, Judge.
Page 4?
Oh, so okay, well, I see it now. It's labeled a different way. So this is actually page 3. This is page 4, line 12. Detective Rogers starts with an 11. Speak up as much as you can.
Line 11, Miss
Wait, let me
Kanarek.
see.
Okay, so some of it,
Okay, line 12. Wait, 10, 11, 12. Shit.
they're
Okay.
numbered on the left-hand
Yes,
portion.
I see. Just the page numbers are in different areas. Okay, sorry, continue.
Does that refresh your recollection as to whether you told them, with respect to the incident, it was a bit shady in your mind?
Probably, yes.
Do you recall telling them words to the effect that after the shooting, you went somewhere?
No, I don't recall telling them that I went somewhere.
Can you look at page 4, line 14? Did you tell them words to the effect? There were parts of the
Let
story,
him finish.
there were parts of the story like, where'd you go? Like, I don't even know, like I disappeared.
Yes, that would be accurate.
This
You
is
told the
maybe
prosecutor's
someone's
office
asking if it
on
is this
that
bad
day.
because they have a bad case or a bad lawyer.
Supposedly after you were
They,
shot.
I mean, I certainly
disappeared
don't see a
somewhere.
robust case here for the defense.
Correct, like mentally. like,
waiting to see what they can pull out of the hat. But this, you can be a good lawyer and
Your
be
testimony is
proficient
that
in working a
by the
bad
word
case. This is not a
disappeared, you
proficient
meant mentally?
cross-examination.
I mean, I could read it, but yes, I could read it out loud if you'd like,
No, just,
whatever you want me to do.
read it to yourself and make
Well,
sure.
he's asking, I guess, what did you mean when you said,
I mean,
back when you gave
you know
that
you're doing a
statement?
bad job on
What-
cross when the
what
judge
did you
has to
mean when
jump
you said
in
those
to
words?
clarify
That's what
for the
he's
witness
essentially
what
getting
the
at.
defense
I think
attorney is
when I
trying
said
to
those
ask on
words,
cross.
I meant, what I thought I was saying was, I think I went somewhere or something, like in my mind, like I spun around in a circle, or, I wasn't like fully aware of I was aware of the fact that I'd just been shot, but also still thinking like, maybe this isn't real. So like, I wasn't in my mind in the proper place, is
Okay,
what,
so as you sit here today,
yes.
at any point in time, either before or after the shooting, did you run off to the side or around the house?
I never ran around the house. Like I said a moment ago, if anything, I may have ran around in one small circle, just kind of assessing myself, but no further, nothing else.
But you never disappeared
No,
physically,
No.
is my specific question.
yeah, no.
Like any other profession, folks, lawyers are on a bell curve, and they're not all on the right end of the bell curve, right? Literally half of lawyers are below average. So be careful when you pick one.
Now, you indicated at some point in time with your relationship with Michael Barisone you decided or set out to try to destroy him, correct?
At some point, I'm sure I mentioned that or said that.
You wanted to ruin his business, correct?
And finally, yeah, that was in my mind.
And you wanted to ruin and destroy his girlfriend, Mary Haskins, correct?
I guess, yeah, after what they were doing to us, that thought had crossed my mind also, yes.
Okay, now, when you say what they were doing to you,
Oh my God, this is painful. She's leading him on cross.
and correct me if I'm wrong on direct examination, where things started to deteriorate is when you weren't being trained by Michael Barisone, correct?
I wouldn't say that when things started to deteriorate. It was part of it, but not the entirety.
What were some of the other parts?
Just things here and there, small lies being told, bullying.
When you say bullying, what exactly do you mean?
I mean,
Who bullied you?
On one occasion, Michael jumped out at me in the dark, started screaming at me and spitting in my face. And at that moment, I didn't know whether he was going to try to hurt me or, I don't know, do something to me.
When was that?
So when is that? Or
Yeah, when was that?
that was sometime around the time that they were no longer living in the house and in the barn. So he was like waiting for me to come up there.
Did you ever tell anybody or call the police?
I posted on Facebook, I'm being bullied by a 6'3" man to the point that I'm afraid, and some other thing. I wrote about it.
And with regards to Facebook, I'm looking for your, with regards to your Facebook account, you were posting things daily, correct?
Yeah, so she can't deny all this nasty stuff that she did towards Michael Barisone because it's all on the internet. She did it on the internet.
Correct?
She posted
Correct.
like multi-page length
And
diatribes against
would
Michael
you
Barisone, her malice towards
Agree
him.
that
That's
some of
all-
those things could be
that's all in the
considered
record.
Threatening.
That's not a justification for
Yeah, I
Barisone to
agree
shoot
with
her.
that.
Like, your use of the terms with regards to a chess game.
Yeah.
Do you recall
Yes,
saying
these
things
should
like
be
the
yes or no
king
questions
will
on
be
cross.
killed, the queen will be
But that
sacrificed?
requires you to
I
structure
don't
the
know,
question so
honestly, I
that the
was
yes or no
talking
answer
about
is
chess
effective for your
game and-
defense.
It might have been an analogy, but
But the analogy was towards Michael Barisone and Mary Haskins, correct?
most certainly.
And you also used metaphors at times, correct?
Correct.
And you did that, to what, try to protect yourself by not using names?
I'm sorry, can you repeat the question?
You used metaphors, correct?
Yes.
And for instance, in one instance, did you use the metaphor where you talk about Michael Barisone as the king and Mary Haskins is the queen?
I honestly don't know who I was referring to as being who, but I'm certain that was about the both of them.
I mean, if he's going for, a sympathy compromise verdict here, something less
On
than
July
attempted murder,
14th, prior to this meeting where the base Mary
Then he
Haskins
needs
tells you to
really-
get out,
just be asking her yes or no
recall,
questions. Did you make this statement? Did you
posting
make
a
that statement? Have her read
extremely
the
long
statement so
post
she looks like a horrible monster,
where
which she
you're
may well
talking
be.
about a king and a queen and your relationship with them.
Wait, I'm sorry, you started out with on July 14th.
But I would note they're
prior
over 20
to-
minutes into this cross, and there's been
I'm sorry,
nothing
can you
yet
repeat
that would
the
touch
question? I'm so
upon
sorry.
any self-defense
I'm gonna show you,
justification.
what he's trying to do here. I'm going to show you 200A-14.
Yeah, so if the judge won't let him read the words, the literal words, that's fine. He's not supposed to be testifying, but he can paraphrase the words. Did you say, in effect?
I'm not sure where the date is of this.
All of
This is from
this,
your Facebook
all of this
account.
asking these questions, so she's
And there's
continually
a
able
date
to
up
say,
top that says,
I'm not sure of the date, I'm not sure of the page number,
7/14/2019.
I'm not sure of
Lauren
this or that
Kanarek
or the other thing,
did that
because he's
post
asking
from
the questions in a
July.
fuzzy and ambiguous way.
Oh,
That
yes, okay, I see. And the highlighted is what
that's
I wrote.
I'm gonna
that
ask you some
strips
questions
out
about
Okay.
this.
the power of the cross.
You're
That
familiar with
diffuses
this
all the
post,
energy of the
correct?
cross for the jury.
Well, I am now, I wrote it, so I'm familiar with it on my page.
And would you admit that it's pretty scary if you're talking about the person that you're talking about here?
Judge, I think that calls for
Yeah,
speculation.
speculation.
Okay.
Just ask her about the post.
When you talk about the adulterous king lured by a peasant of no merit, no credibility, and ousting the rightful queen in the most humiliating way in front of a large audience, who is the king you're referring to?
Probably Michael.
Probably,
Yeah, I'm assuming I'm not referring to his ex-wife Vera,
right?
so therefore it would be Michael.
And who is the new queen you're referring to?
Mary Haskins.
And did you call her the most dumb-witted commoner, village idiot, would suit her perfectly, known in all the land? She is not royal blood. She has no regal talent or talent whatsoever. Did you say those things about
Yes.
Mary Haskins?
But this
Yes.
this woman's not on trial for being a witch.
Others refer to her as the queen of lies and deceit. I myself have not found it necessary to refer to her at all. Did you say at some point?
You don't get to shoot people because they're
referring to
mean.
her, that she herself could never possess the talents that the wife did. She was blinded and paranoid with jealousy and the thought of the king realizing her true nature. She began
folks-
executing all the younger and fairer maidens of the kingdom.
Is somebody backing up a
Yes,
truck?
yes, I wrote that.
You wrote that?
Of course, yes.
And you're referring to Mary Haskins, correct?
Yes.
Now, you were aware that Mary Haskins, Michael Barisone, and pretty much everybody at the stables were following your Facebook account, correct?
I had no idea what anybody was doing at the stables regarding my Facebook account. Other than maybe
I mean,
Michael. on
People like
occasion.
this woman, folks, they
Sometimes
have
sending
power
salt
over
posts, I
you
mean,
and your emotional
when did you
state
say
and your
that?
conduct, only to the extent you
Sometime
give
while I
them
was training
that.
with him, it might have been
Unfortunately,
shown to him by a girlfriend or
there's been evidence
maybe he saw it
suggesting that
on his
Michael
own,
Barrison was generally a pretty
complimented it.
fragile person.
there was some
So he was
Complimented
vulnerable
it?
to this. But
Not this
people
post,
like this, when
a
they
post
realize
at some
which
point,
buttons they need to
and he was
press
just
to
like,
get
"I
you
agree with
agitated,
everything that you wrote,"
man,
and
they'll bring a hammer the next
other
time
than
they
that,
hit
I have
that
no
button.
idea what he does with his Facebook account or what he reads or who shows him what.
Did you also say in this post?
The person shuffling the
Sadly,
papers
the once
is this
fearful
judge.
and
It's
formidable
horrific.
king,
His
Michael,
microphone is 10 times the volume
have
of
been
everybody else,
transformed into
and he shuffles
nothing more than a
papers and
slight
clicks pens
memory
relentlessly.
of his glory days, with less and less tales to tell of conquering than ever before. Did you say that?
Yes.
Did you say a man made small and nearly worthless without his queen by his side?
Oh, yes. I wasn't sure if you were finished. Sorry.
And did you also say the more frail the king became, the easier it also became for the imposer, wannabe queen, to whisper lies into the king's ears. Did you say that?
Yes,
And you were referring to Michael and Mary Haskins, correct?
correct.
Judge, just so the record is clear, it says imposter.
I apologize, I read it.
All right. The record shall so reflect.
Lies she hoped would rid every maiden, young and old, of true royal blood, and with varieties of talent from the kingdom forever. Were you suggesting that Mary Haskins was trying to destroy the careers of all the young people at the stables?
Yes,
Did you then say at some point, failure to abide by his agreements with other royal houses invite open war and inevitable destruction?
yeah. Most of it.
You were basically declaring war on him, correct?
I wouldn't go that far.
Well, there were certain agreements that you claimed that he didn't honor with you, correct?
Correct.
And this post was referring to those agreements, correct?
I mean, yes, it's also a reply to a comment that mentions things like royalty and other things. So there's parts that I honestly don't know what I'm talking about, but it was written by me, so it's there. Yes, I wrote it.
Open war and inevitable destruction on a Facebook post, folks, is not an imminent threat. It may be a threat if you choose
Did
to
you say
interpret it that way. It's
unfortunately-
ambiguous. No one's literally going to open war, whatever that means, in an interpersonal context. But if it's posted on the internet, it's not an
What-
imminent
I'm not
threat.
sure
It's
what
not a
it
threat
means.
that's immediately about to
Did you say,
take place.
unfortunately, IQC, imposer's queen commoner, used the king's diminished state.
And for those who are
Quietly
arriving now,
convince
this
them
is the cross-examination
ignore
from
all
yesterday.
treaties.
So I'm live, but
I
this
have
is
no
the
idea, 'cause I have no
recording
clue.
of yesterday's cross.
Oh, IQC. There actually is a thing for that. I'm sorry, could you read that again, just so I know exactly?
First, do you know what
Right.
ICQ means?
Yeah, I see it. I put it in parentheses,
And what does it mean?
air brackets. It means, I just saw it. I will get to it. Imposter queen commoner.
Did you then say the queen on the glass throne isn't a queen?
Yes,
She is hardly more than pond scum attached to the boot after trudging through a puddle. Did you say that about Mary Haskins?
yes,
So far, the
You
take-home
realize
message is
Mary
people
Haskins
suck.
was his girlfriend, correct?
correct.
Did you think if he saw that post that would cause an issue with regards to you staying and training at his facility?
Okay, I'm sorry, I just wanted to make sure I have the question right. You're asking if I thought,
If he
What?
saw this, whether it would cause an issue with him continuing to train you and allow you to stay at his facility?
I don't know, but I thought really hard about it. or
It doesn't matter what the
consequences.
process is to get these people to leave,
You
or if the
just threw it
process
out
sucks, or if it's not available to you, or if you feel you have no options. None of that privileges you to shoot another person.
Did you then say, her open attacks on me will not result in the execution as it did for the maidens fairer?
I
And
would
she,
suggest,
without
folks, by the
any
way, that
counsel
it
to
seems
fairly
unlikely
protect
to me that this
you
is the
made a
first
statement
time this woman has
that.
expressed herself as a
I'm
sociopath
guessing it's
in
there,
her
yes.
interactions with
I'm
others. She's
saying I wrote
40-something
these
years old when
posts,
these
so
events are
yes.
going down. Other
And-
people have encountered her other people
He
have
ended
dealt with her
by
personality and
saying something
character.
to the effect,
Did Michael Barisone do
"But all the
anything to
king's
vet her
horses
before
and
he
all the
invited her
king's
to
men
live on his
couldn't
farm,
come
live
be
in his home?
together again."
Because once you do that, it's almost impossible, especially in New
And
Jersey, to get rid of the person who's residing there.
castle
It becomes their home.
would come crumbling down. Did you say that?
Yes.
And the castle you were referring to was his business, correct?
I honestly don't know what I meant. I don't know.
You have
Again,
no
I was
idea
just writing,
what you meant when you wrote this. Is that your testimony?
that's my testimony. I have no idea what parts or pieces of each micro thing I was referring to. It's social media. I wrote stuff. That's what I did.
That's her
And you
her
made a statement at
justification.
the very
Hey, it's
end,
social media.
to the
You talk
effect,
shit
"I
there.
sure hope my wrath
And frankly, that's
is
not a hard
never
sell.
called upon." Did you say that?
Yes.
Judge, could I ask for completeness pursuant to the rules of evidence that the next line be read?
Judge, if he's asking that, I would ask that the entire thing be published to the jury.
You have redirect.
That's
You
fine,
can
Judge.
do it on redirect.
That's fine.
Mr. Belinka's brought it up, and if you want to bring in other portions of it, you can do so. That's why we have redirect.
Now, you were also posting things about your mental instability on Facebook, correct?
Not that I recall. Not seriously, anyway.
When you say seriously enough, did you make specific mention of you having serious mental problems?
I do recall one specific post.
Which one was that?
It was a post sometime, I don't know when I wrote it, but it was a post in reply to my cousin, which the gist of the post was fear. And I discussed hiding in a bunker or needing to hide in a bunker. But prior to stating that, I say something along the lines of, I like have mental.
You can't allow a
sorry,
witness to do this on cross. This is ridiculous. I mean, she's just
trying to think of what the words were.
engaged in dialogue at
Yeah,
this point.
multiple personalities. I don't know what they're gonna do if they're threatened, which is actually like a little bit of assumed knowledge on the part of the person I was sending it the message to. I thought she like knew the situation and that would understand that I was referring to Michael's behavior.
For those of you who are
One
law
way,
self-defense members who were having
one
trouble
way
with the
next
video
day.
on your membership
And I
dashboard,
just
I just got a
was
thumbs up
writing it and assumed that she
outside
had
my
more knowledge
office,
of,
so
like,
that should be working
whole
now if
thing
you'd rather be there.
than she
We
did.
do
So to
prioritize
be
the
sure,
questions
I then
asked
went on to
there.
say, we're so frightened that we're thinking of building a bunker to hide ourselves and maybe even can it fit horses. If you have the post, you could bring it up.
And I see David for sure is there posting
I was just
in the
saying.
chat.
Sure,
So
your time. So you do admit that at some point during this relationship, you posted something saying you had multiple personalities and you're not responsible for your actions.
Yes, I did post that.
Did you ever post anything that you're a narcissistic and suffering delusions of grandeur, hashtag bipolar narcissist?
Possibly.
would you agree that you're a witch?
Those are the
Yeah,
types
sure.
of things
I'm a witch.
You would say?
There's lots of types of things I would say.
Does anybody doubt that this woman
So,
spends hundreds, if not thousands, of hours a year
Did you make
on social media?
reference to weapons frequently?
Not that I recall, but I'm sure I mentioned that I own a gun. Sure, I mentioned that New Jersey gun laws are very strict, and other states maybe that have gun laws that are very strict also, as they should be. Especially since I ended up getting shot by one of those very guns. So.
Well, I guess the gun laws didn't help.
Do you recall,
New Jersey strict gun laws didn't keep you from getting shot, did
do you
they?
recall posting photographs of on Facebook of you shooting your boyfriend's motorcycle because you were angry that he who's riding without a
Judge,
helmet.
Yeah,
This is subject to a rule.
yes. Where are you going with that, Mr. Malenkas?
So for those asking, how could her boyfriend ever date this woman? I've heard it rumored that there are identifiable benefits in the short term to the crazy. I've heard that said. I personally would not think it's worth the the consequences, but there you go. Some dudes get drawn into that. All right, let me hit a couple of, let's see what we have here for LOSD member comments. David, they're all from David so far. This lady is certainly a witch and not a nice person. Yep. I would never let someone move into my house. Roommates are terrible. There's a good deal of wisdom there, folks. Once you let someone move in, getting rid of them is can be a months, maybe years long process. And in your own home, now you're dealing with them every day. I really expected this lady to be quite a bit younger. Yeah, me too. I was shocked when before I ever saw a photo of her. I assumed she would be in her 20s, learning how to engage in an Olympic sport, but nope, she's in her 40s. Nothing wrong with being in your 40s, folks. I'm in my 50s, but a bit more aged than I would have expected of an Olympian athlete.
Rephrase your question.
You
And please,
testified
hold on, and please keep your voice up nice and loud, okay?
Okay.
So all the jurors in the back
Okay.
have to hear you.
Yes,
All right.
yes, Your Honor.
You testified on direct that you only owned one gun.
Correct.
Okay. Did you post that you have two 9mm Walters?
Yes, I did actually post that.
Did you lie about how many guns that you possessed?
No, I was not lying about it. I was talking to a friend of mine who he and I frequently discuss politics and what have you. And in this discussion, what I was referring to was the gun that I had currently. I had also, at the same gun store, put money down on another gun, which I never went to go get. And instead of explaining like what would have been a 17-page thing,
This is
I just said,
the kind of response you get from a
guns,
witness on
but
direct, folks,
that guy
not
would
cross.
certainly
This
know
is
that wouldn't be the
an
case,
extraordinarily
because I
poorly
wouldn't
run
need another
cross.
permit to go get it. So in a simple sentence or two, I just said I have two guns, both Walters, which is technically true, seeing as though I did put money down to purchase that gun. I just never went to go get it. So
It's
I didn't feel like explaining that on Facebook. So I didn't.
so it's your understanding that if you put money down on something and don't pay for it completely and obtain it, that it's yours?
This is
Guess
this
that's
is
the
nonsense.
concept of putting something on layaway or things like that. So
When
that
did
was
you
my
put-
interpretation.
Right.
Yes.
When did you put that on layaway?
Sometime around the same time that I went to go do the whole process of purchasing and actually obtaining the first weapon.
Did you post that you have a 9mm?
I mean, watching this narcissist on
Under
cross
your
would be a
pillow.
lot more fun if legal counsel was
I
more effective.
Don't remember, it's possible.
Watching a narcissist witness on cross and a not very effective attorney stumble over each other like a legal mosh pit is
Now, with regards
mosh pit of
to
blind people.
your statements concerning owning two guns, both Walters 9mm pistol, one takes 18 in the mag and one in the chamber. The other is small enough to fit in my purse. I haven't cleaned it in a year.
Yeah, I was actually referring to the one I had, not the one I didn't have yet. But yes, I wrote that.
Which one is the one that holds 18 in the magazine?
The one that I actually have possession of, and I'm pretty sure it's 17, now that I checked it like recently.
In that same post,
Yeah, I don't know.
which is on August 4th, 3 days before the shooting,
Mhm.
did you say words to the effect, that if someone were to punch me in the face, I'd let them twice. After that, their second hit advantage would be over until they begged me to let them up.
Probably, but something sounds unfamiliar about that. Could you maybe read the few lines preceding that? Or like maybe however many lines there are, just a few lines that read
Sure.
before that, so I know.
I haven't cleaned it in a year. Hashtag fail. Unfortunately or luckily, we both live in North Carolina. New Jersey is crazy gun laws. You could be arrested to do time for just having one bullet. Mine are mostly hollow points, which just one is a potential of 10-year sentence, even if it's loose and sitting on the floor.
That couldn't be the post, because that post, where after it says luckily, it says, I'm not a violent person.
Right, that's
You
the,
didn't read that just then, so I was confused. You read that
okay,
sentence was
I'll
confusing.
read the whole thing.
Yes, please do. Thank you.
Potential 10-year minimum sentence, even if it's loose and sitting on the floor. Also, luckily, I'm not a violent person. I hate confrontations, which seem they could turn violent. That said, if someone were to punch me in the face, I'd let them twice. After that, their second hit advantage would be over until they beg me to let them up. Hashtag self-defense.
Yes, that's the correct post. I did write that.
And so you were telling whoever had access to your
Is it
Facebook
true that law and crime thinks this defendant is
that you own
innocent?
2 different guns, correct?
I should say not
Correct.
guilty.
And that I wasn't violent, but yes.
It'd be interesting to know what that is based on. I mean, granted, I haven't
Yeah.
really been watching the trial, so I guess it's theoretically possible.
Were you posting things with regards to your
Oh,
experience?
that's the judge
using
and his
guns?
papers. I don't know what he's doing with all those
Probably.
papers.
For instance, that your ex-husband owned a gun shop and you shot pretty much every gun there is.
Yeah. It's fair to say.
Did you brag about being a better shot than your boyfriend?
Probably.
And did you say
Not
at one
uncommon,
point
by the way, folks,
with
for
regards
women to be
to,
better shots than their
your
male
gun that you
partners.
only need 3 bullets? My aim is nearly perfect.
I don't know, could you read that? I have no
Judge,
idea.
can we be heard at sidebar?
Yes, I think we should.
I'm waiting for the judge just to like grab a half full bag of potato chips and smash it on his desk in front of the microphone. I mean, this is ridiculous. Is there no one there to tell the judge what he's doing? Jeepers. It's been going on for days now. So I see someone right here. The other witnesses have been crucial to the defense. If we're talking in this case, I'd like to know how crucial they could have been because they were not witnesses to the physical confrontation that resulted in the shooting. So what would their testimony bring to the table in terms of justifying the shooting, which is the key issue in this case, justifying or excusing. So I distinguish between those two because there are legal excuses that remove criminal liability and legal justifications that remove legal liability. And they're technically different. So an excuse applies where we don't want to hold someone legally responsible, but we're not saying that the outcome or what they did was good. And this might be like a literally insane person thinks he's shooting a Martian, really, but he shoots a pediatric oncologist. That's not who's doing nothing to him. That's not a good outcome. Society lost a pediatric oncologist who wasn't doing anything to harm anybody, and they got killed for no good reason. That's a bad outcome. But we might excuse that as a criminal offense because of the shooter's clinical insanity. So that's a legal excuse. A legal justification is different in the sense that while it also relieves criminal liability, the outcome is deemed to be a social positive. A woman shoots and kills the man trying to rape her. Well, I mean, to some sense, it's nobody wants anyone to die, I guess. But if we have to choose between
All right, ladies and
the
gentlemen, the
rapist being
objection was
successful or the
sustained. And
rapist being
Before we go
dead.
any further, I do have to give a limiting instruction on some of the testimony you heard. You heard me mention earlier, I think after openings, that there were some uses for evidence that are allowed by the jury and some uses that are not allowed. And I'm going to go through all this again at the end of the case when I give my main charge. And I'll give some references at that time to specific evidence and how you can use it. Now, this evidence about Ms. Kanarek owning a firearm was allowed in by the court for a limited purpose. And that purpose is, as it may have affected Mr. Barisone's state of mind at the time of the shooting. That's why it's allowed in. If it's shown that Mr. Barisone had knowledge of these postings, you may or may not consider that as evidence of his state of mind. It's entirely up to the jurors, but it's not introduced to somehow attack the character of Ms. Kanarek. It's not introduced as character evidence.
It's
only
New Jersey,
introduced
so
for
you
a
have to
limited
caution the
purpose
jury
of how
not
those
to
postings may
think
have
badly of the
impacted
woman's character
the
because she
state of
owned a
mind of
gun.
Mr. Barisone.
As if
That's
there
the
isn't
only
plenty of
reason
evidence
the
already
court has
to think
allowed
badly
the
about her character.
introduction of this evidence regarding Ms. Kanarek's possession or ownership of a firearm. All right, and I'll address it more at the end of the case. All right, please proceed, Mr. Belinkus.
Ms. Kanarek, did you refer yourself as John Wick in any post?
Maybe,
Who is John Wick?
A man whose
Someone
puppy got
like-
killed.
Keanu Reeves.
It's a violent person?
I think it's a matter of perception. You could say that, I guess.
Did you call
Yeah,
him?
Mr. Belinkus.
So one thing that's going on here is the judge is well aware that this woman has probably millions of social media posts, and he doesn't want this defense attorney just to read through every one that might potentially make her look bad. They've made her look bad. If there's going to be more social media reading, it's got to be relevant to some legal issue or with respect to the crimes charged or the legal defenses relevant in this case. If he's trying to act crazy, it's working.
Belinkus.
Were you posting in numerous posts statements with regards to going to war?
Yeah,
Did you say things like, if war cannot be avoided, then the victorious warrior must hashtag win first, hashtag then go to war, or words to that effect?
yes, I believe I was quoting some too, but I'm sure it's probably posted if it's hashtagged and posted.
All this stuff only matters if at the moment of the use of force by Barisone, she was making some kind of threatening conduct towards him. Then the prior threats are relevant because they go to the reasonableness of Barisone's perception of that actual imminent threat in the moment. But absent the actual imminent threat in the moment, the prior ambiguous references to war on Facebook mean nothing.
Every
Legally.
time I up my chess game, I always become reminded that it is those who obsess about protecting their queen, regardless of the outcome, who miss the hiding and always fail. Did you say something like that?
Probably.
And you were talking about Michael Barisone protecting his girlfriend, correct?
Probably.
And in that same post, did you say,
Can I ask what date you're looking at or page or something?
this is
The prosecutor should state, Your Honor, we'll stipulate this woman is a horrific bitch.
2019? And at the end of that post, did you say, the king has been captured and killed, and the whole entire castle comes crumbling down? Did you say that?
Probably.
And
Probably.
that
Did
sometimes
you say
the
this heinous
queen must
thing?
be
Yeah. Have you met me? Probably.
Did you say that?
Yes.
So will you admit, with regards to this post, you were talking about capturing and killing Michael Barisone, with use of metaphors, of course, correct?
I was definitely not talking about killing anyone. That'd be false.
How about sacrificing the queen? Was that Mary
Um,
Haskins?
On a board of chess where a piece is knocked down or moved over. Sure.
On that same day, did you post something, the beast?
To the person asking
hasn't yet
if there's a
met
threat
the
such as the next time I
beast
see you, I'm going to kill
inside
you,
me.
could that be used to
Objection.
justify defensive force? Not by itself.
Same objection, Judge.
There has to be some overt physical
I'm sorry?
action that from which the defender could infer that the threat is in fact imminent.
No, I'll sustain the
Words
objection.
alone or written threats alone, absent that overt physical act, are not enough to justify defensive force. There has to be some overt physical act. Now, if there is some overt physical act, what those words can do is minimize how much of an act you need to see.
Now,
That's definitely possible, but by
during this
themselves,
time
the
when you're
words are
making
not
these
sufficient to
posts,
justify
you're
defensive force.
telling numerous people on Facebook that you're being bullied, correct?
Yes.
And you even tell them that you believe your life is being threatened.
Hey, folks, those of you watching on YouTube, I always forget to mention this, but if you could please hit the subscribe button, hit the like button. We're
Now, with
within
regards to your post,
we're within a very narrow range of hitting 30,000 subscribers. I don't get any kind of special money or
July
anything for that, but it would just be
21st,
a nice
2019.
thing to have happen.
After posting all these things,
I think we need,
which we've
let's see
just
where we
gone
are.
over, did
104
you say something to the effect
subscribers
that
short of 30,000. So
never
if you're
be
watching this on
bluffing,
YouTube and would
never
please
be
pound that
bluffing,
subscribe button,
not
that would be
unless
greatly
you're
appreciated.
prepared to
You need to be a
carry it
subscriber
out.
to comment anyway.
Say words to
Hit
that
the
effect.
like button, thumbs
I'm
up,
sorry, what date?
leave a
and
comment.
what
That
is-
all
This
helps
is
fool that
July
horrific
21st.
YouTube algorithm.
Couple weeks before
Thanks,
the
guys. I
shooting.
appreciate that.
Did
Okay.
you make a statement basically saying you're not bluffing, or words to that effect?
Maybe. I don't know what the context was, but
What page is that? Top right.
Yeah, women like this are horrible. I mean, humans like this are horrible. It doesn't have to be just a woman. And any kind of bully is horrible. And they're particularly good at targeting vulnerable people, people who are vulnerable to having their buttons pushed. If you're resistant to that, being targeted by a bully, in this verbal way, it really has no effect. It would be pretty hard to bully me in this way because I just don't care.
And on
But
July
to people who are
21st,
vulnerable, they're just like any predator. They
you
perceive
dare
when their prey is
again
injured,
talk
and they
about
just
what
double
you're
down and
saying,
triple down and quadruple down until
not
they've
being
crushed
bluffed,
their prey. And that
and that
appears to
no
be
one
what
with
this
a
woman
brain in
has
your
done to
head
Michael
bluffs
Barisone.
emptily.
Doesn't justify him
literally.
shooting her.
You do and just did. Bye-bye, exclamation point. Did you say that?
yes, I always usually end off with bye-bye or bye-byes. So that makes sense.
When you say you normally end with bye-bye,
If it's anybody, yes.
For those of you who are writing that I might care about this kind of person if they were a tenant in my property, that's why they're not, folks. That's why I don't do that.
Now,
And again, I have to believe that Michael Barisone did effectively no vetting of this woman.
July
She didn't become a
23rd,
sociopath,
couple days
narcissist
later.
in the instant she met Michael Barisone and got to live in his house. I expect she's
Did you
been
use
this
the
way her
term
entire adult life,
weapons
probably
hot?
her entire life.
Yes.
She's encountered people before. She's dealt with people in this way before. These things are
July
knowable.
25th,
She's in her 40s, folks.
did you
She's not,
post a post?
there's a track record there.
And this is when things are really starting to get crazy at the facility, correct?
Yes. I'm sorry.
So someone writes that the defense
Can you
says
just go
that
back to the
this
post a
woman
minute
and her
ago?
boyfriend attacked Michael
About-
Barisone and
Moving
sicked
on.
the dog on him
Oh, okay.
before he shot
Because
her.
I've
So I
seen
watched the opening
On
statement of the
July
defense, and they
25th,
never said
did you
before.
post,
They said Michael
I
Barisone was
will
beaten
be-
and he was bitten by the
It's
dog,
about
but for
time
some
to
reason, the defense
possibly
lawyer did
go
not
to
say
war.
before he shot them.
Anyone who repeatedly
Well, that would be
kicks
kind of a
or
critical
rests in
fact. So the
peace
fact that the defense
will
did not
eventually wake
make that
her up.
explicit suggests to me that the
Probably,
evidence
yes.
there is ambiguous. It would not be surprising if you shot someone's girlfriend or fiance twice in the chest that the boyfriend may take offense and give you a beatdown. That the couple's dog
On the
might not
27th.
bite you in defense of its owner.
Did you say words to the effect, "This is me, look out, because here I come"?
Yes, I believe I was quoting about the circus movie with Hugh Jackman. It's like literally a song.
So I see Emma follows up. She says it was today that he said it. I guess today the lawyer said that the beating and the dog bite occurred before the shot. If that's the case, and he didn't say it in opening,
Now,
that's a catastrophic failure of this defense counsel.
you okay?
I'm just looking for the page that you said to look out, because here I come. But what page was that?
All of this she's
No, I
doing
don't
now.
think that's
All
on
of
there.
this
I
I
He's
can't
looking at
find.
something completely
Oh, okay.
different.
I'm sorry. I'm sorry.
I can't find the
Why don't you
page. I
take that
can't find
away
this.
so we don't
Okay.
have that mistake again and have her
Okay, yeah, I
looking?
wasn't sure
You're not
what was
referring to
She,
it.
this lawyer's not in control of his cross-examination. He's allowing her to diffuse all the energy out of it. In fairness, there isn't that much energy in it.
Now, at some point, you start illegally recording private conversations, correct?
Objection.
Close to a conclusion, Mr. Belinkus.
Did you record private conversations where you were not a party to?
Yes.
Now, at some point in
To
time,
which you were not a party.
and correct me if I'm wrong, I believe on August 3rd, you tell the Washington Township Police Department that you've recorded secret conversations, correct?
Yeah, I told the police that I was recording things, yes.
But you also lied to the police about that recording, did you not?
I don't know in what capacity you're talking about, so, no. I would say no.
Did you tell the police that an attorney gave you permission to record?
I don't recall, but I was speaking with attorneys and,
What attorneys were you speaking to?
I guess I could tell you their names, but I'm sure it's privileged. Ed David, my father who's a retired attorney. There's someone else, I don't know that they're involved this time. I don't remember, there was definitely somebody else, I believe, but certainly those two people. One is a current attorney, one is a retired attorney, and we discussed.
Somebody asks here,
Location,
Anthony, couldn't the
what the
case be that she
expectation
mentally
price
tortured
might
him to
be
the point
for
he
reasons
thought the
of
only way
which-
out
And
was
the
it being
legality?
him or her? Yeah, that
and
could
the
definitely be
legality,
the
of
case.
course,
Unfortunately, that
a
neither
decided
excuses
thing
nor
for a
justifies
judge,
him
but
shooting
we
her.
discussed those possibilities, so that we could avoid doing something illegal.
All right, so, and again, correct me if I'm wrong, is it your testimony that your father told you you could legally take a private conversation that you were not a party to?
Objection. It's hearsay.
What's the basis for your objection?
It's hearsay.
Not offered for the truth of the matter, Judge.
What's it offered for
It
then?
has to do with why she did this.
I'll allow it. Not for the truth,
Correct.
just her state of mind.
It's your sworn testimony that your father told you, a lawyer, that you can put a recorder someplace and record private conversations when you're not there.
No,
Is that it? Is
No,
that,
it's my sworn testimony that either my father or the lawyer that we had obtained expressed that it was their belief that the location in which the device was placed, and the reason for which it was placed there, seeing as though it was considered my property, was not breaking any laws. We specifically sought out this instruction or counsel to be sure that we were not going to be breaking any laws by doing this.
okay, I'm asking
We
you.
weren't trying to
Right.
shoot anyone or kill them. We just wanted to do things the legal way.
I'm asking you specifically, was it your father?
She just said, that's asked and answered. She said twice now, either the father or the lawyer.
Okay, well, are you aware of the fact that I have a tape recording of the meeting between you, Robert Goodwin, your father, and your attorney, Edward David? where you're
Again, either the
discussing
recording
tape
would be
recording?
legally permissible
I'm
or
not
it would
aware of
not
what
be
you
legally
have,
permissible,
but
but
we
none
have
of
been
that goes to
conversations, so
anything
we
more
have
than her being a horrible
conversation.
person at worst.
Then you have a conversation.
I have a
Yeah,
conversation,
No, Mr. Blankus, you're not offering evidence.
have you heard, Judge?
All right, let's take our afternoon break. Members of the jury, take 20 minutes.
All right, so that's the end of this first segment. I should mention before we go on that today's Law of Self-Defense content is sponsored by CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. Let's see if I can make that a little more attractive. There we go. In effect, CCW Safe promises to pay their members legal expenses of the members involved in a use of force event. Guess they're chatting while the jury's out. Oh, it looks like it flipped over to the live coverage today, so I'm not gonna jump into that. I've cut off the audio. CCW Safe, provider of legal service memberships, pays their members legal expenses if they're involved in a use of force event, and those expenses get big fast, folks. Very common in my experience for legal expenses in a killing case, murder or manslaughter, or attempted murder or attempted manslaughter, to exceed $200,000 before you even get to trial. So if you don't have that kind of money stuffed in a mattress, it can be helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depends on it, because it really does. I've looked at all the companies that offer this kind of service, as you might imagine, and I found that CCW Safe is by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member. Whether they're the best fit for you is something only you can decide, but I would urge you, if you're interested in this kind of coverage, to at least take a look at what CCW Safe has to offer. You can do that at lawofselfdefense.com/CCW Safe. And if you do decide to become a member, you can save 10% off your first year of membership with them using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCW Safe. I'm going to jump into the questions here But before I do want to mention one more thing that many of you may not be aware of, and that is that we have a series of 100% free webinars coming up. We're calling these our Hard to Convict webinars. We have a number of these. They're all the same, so you wouldn't want to attend more than one. We have a number of these scheduled over the course of the next month. They're 100% free. They do a bunch of myth busting on self-defense law, explain why believing those myths is dangerous to your liberty. And really, if you believe these kind of internet law-based myths, you're just preparing yourself to be convicted and imprisoned. And we're making these 100% free to everybody. Now, we do limit each webinar to 100 people because we want to make sure we have enough bandwidth to do effective Q&A for each one. So I would urge you, if you're interested in attending, to sign up sooner rather than later. You can learn more about these at lawofselfdefense.com/hard-to-convict. They're free, folks. They don't cost anything, but there are limited seats. So if you're interested, sign up at lawofselfdefense.com/hard-to-convict. All right, so let's flip through first our law self-defense member questions. Let's see. Yep, okay, I think I've answered all of those. Let me take a look at the super chat stuff. Okay, all work, no play. Thank you for your super chat. I apologize. All work, no play's comment is I'm a law self-defense member. Can't see this on my dashboard. I think we have that fixed. Sorry about that. TH, thank you for your super chat contribution. Would you at some point cover or explain the Crumbly trial? This is the Oxford, Michigan school shooting where the parents have been criminally charged because their son shot up his school. Apparently, they provided him with the gun or access to the gun, or frankly, I have not been closely following the case. I think the application of criminal liability to the parents here seems sketchy as heck to me. It looks like that part of this is really just a politically motivated prosecution. It's not the kind of trial I would normally cover. I mean, I'll take it under advisement. I mean, it's clearly not a self-defense case, so it's not a justified use of force argument being made here. But perhaps if things are otherwise slow, I'll do some digging on that case and do some trial coverage. William Andrews, just catching up since I missed yesterday. Just wanted to let you know that you have incredible guests. So if you didn't catch this, folks, yesterday we had on a defense attorney from South Dakota, Marshall Lovren. He recently won a self-defense trial in South Dakota. His client was charged with murder. Very interesting facts. But the reason that Marshall had originally reached out to me after he won the acquittal for his client is that he says he found our book, The Law of Self-Defense, and our instructional courses and materials and coverage of trials to be materially helpful to him in winning that acquittal of his client. He just wanted to let me know that, which of course is incredibly humbling. And then he agreed to be interviewed on the law of self-defense. So that was yesterday. So if you'd like to catch that, you can find it on our YouTube channel, or law of self-defense members can find it as a regular blog post as well. Yeah, he was great. Fantastic lawyer. If you want to know what a good criminal defense lawyer looks like, check out that interview with Marshall Lovren yesterday. It was fantastic, just fantastic. Not just the interview, but he presents as a really, really outstanding, conscientious, hard-hitting criminal defense lawyer, exactly the kind of person you'd want on your side. I doubt that Mark Richards had read my book, unfortunately. Listen, Kyle Rittenhouse got acquitted, and I'm happy for that. He ought to have been acquitted. He ought never have been charged in the first place. And there were parts of that legal defense that were very good, but the opening and closing by Mark Richards were not among them. Okay, let's see. And I'll take as long as we're on a break, I'm sorry, folks. I try to flip through the non-super chat questions, and there's just too many, so they all blend together. That was the case. South Dakota versus Jared Jones. Correct. That was the acquittal won by Marshall Lovren of his client, Jared Jones. Let's see. Yes, it's very humbling. Of course, we hear this from attorneys with some frequency. We're very fortunate when we can, good criminal defense attorneys don't have a lot of free time. So we're very grateful when they can spare it for an interview. We did another attorney who won a case with the help of our book and content just about a month ago down in Florida. So we encourage you to take a look at those. And it's humbling. I'm really an academic lawyer. My legal practice is legal consulting to lead counsel on their clients' cases. I don't take clients directly. So you become a step removed from the being in the arena, go to court lawyers still doing that nuts and bolts work. And sometimes you wonder if you're being effective in helping those attorneys achieve acquittals for their clients that deserve to be acquitted in self-defense cases. So to the extent those lawyers can affirm through their wins and through their praise that what you're doing is helping them, that's enormously humbling and gratifying for sure. I don't know anything about the self-defense laws in the UK. What often happens, I don't know the UK self-defense law. Sorry. What often happens here in the US is self-defense law is pretty much the same across the 50 states. About 80% the same. The underlying principles are the same. That's why we can talk about the 5 elements of self-defense applying in all 50 states. Where we tend to see practical variance here in the US across the states is not in the black letter of the law, but in how it's applied by prosecutors in making their charging decisions. More states more favorably disposed to self-help in the form of self-defense are less inclined to bring a case to trial to prosecute someone who acted in self-defense on a given set of facts than would be a state like New Jersey or Massachusetts or New York, where they like to put you to the witch test. They like to throw you in the river and see whether or not you float. And if a jury acquits you, then a jury acquits you. But they're going to put your claim of self-defense to the test in trial, which is a horribly destructive process and not something that should occur unless, at a minimum, there's genuine probable cause that your use of force was unlawful. In other words, that it's more likely than not. But in those anti-self-defense states, you see prosecutors bringing cases to trial where there's, I don't know, maybe it's 95% certain that it was self-defense, but there's a 5% chance it wasn't. And they're going to subject you to the punishment of the process on the basis of that 5%. That's not the way the system is supposed to work. But prosecutors are free to make those kinds of decisions in that way. And the almost certainly not guilty defendant pays a catastrophic price. And that price is not just money. It's maybe everything they value in life. I mean, divorces are extremely common, loss of businesses, loss of reputation, loss to friends. Life as they know it is over, and that assumes they're acquitted. Obviously, there's always a greater than zero risk that they're actually convicted, no matter how innocent they may actually be. And then life as they know it is really over. I mean, potentially they're in a cage for the rest of their lives without possibility of early release. I always caution every case I consult on. I caution the client, listen, we can go to trial. We can fight this. You've got merit. But keep in mind, no matter how strong your case, there is a 10% chance that if we put this in front of a jury, you get convicted. That's just the noise in the system, folks. So that's the risk. That's the risk you take. Make sure that, if you're going to incur that risk, you're doing it in an informed way. All right, folks. Well, I have like another hour of this, but I think we've been going for an hour and a half already, and it's not very compelling stuff. This is what I'm going to do. I'm going to take a break. I think maybe I'll take my wife to lunch and perhaps start up again in the afternoon, hit the second hour of cross-examination of this witness from yesterday, and maybe see what we get out of that. But for the time being, I think I will prepare to sign out. I will just remind you of our webinars, lawselfdefense.com/hard to convict to sign up for one of our 100% free myth busting law self-defense webinars we're holding over the course of the next few weeks, limited to 100 people each, folks. So I guarantee you they're going to fill up very quickly. So if you're at all interested, please point your browser to one of those, to lawselfdefense.com/hard-to-convict and take advantage of that opportunity if it's of interest. All right, folks. That said, remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're also hard to convict. All right, folks, perhaps I'll see you this afternoon. In any case, until we meet again, I remain Attorney Andrew Branker for Law and Self-Defense. Stay safe.